All right. Well, welcome once again to Facebook Live, to YouTube Live, to social media live. We're live. I'm live. My name is Lior Samfiru. I'm the employment lawyer, and hopefully by now you know what we're here to do. We're here to talk about employment law. We're here to talk about workplace rights. We're here to help you solve those workplace solutions. We are live, and we are here to answer questions. So the point of this is, if you have an issue, a workplace problem, a dilemma, if you're struggling to know something that your boss did, is it legal? Can they force you to do something? Maybe you lost your job. Maybe your job has changed. Whatever the change, the issue, the problem, ask the question. Now is the time to ask that question so that I can answer it, so I can tell you what you need to do, so that I can tell you why those issues that you're dealing with are actually not that bad. There are solutions. So again, my name is Lior Samfiru. I'm a lawyer and partner at Samfiru Tumarkin LLP. We operate across Ontario, BC, and Alberta. So if you are in those three provinces, we got you covered when it comes to employment law. So right now, this is the time to type in that question so that you can leave here with answers. Now, of course, if you want to connect with me or anyone on my team off social media, if you want to have a private discussion, if you want to deal with your matter just between us, not a problem, easy to do that. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. And first of all, there you can learn a lot about employment law, about workplace rights, about developments in the law. But importantly, you can also contact me directly from there. You'll see phone number, email address, fax numbers. There's forms you can submit if you want. So there's all kinds of ways to contact through employmentlawyer.ca. But that's for after. Right now, for the next 30 minutes, I'm here, I'm live. All right. So if I'm live, that means that you can ask me questions. You can get some of the knowledge that I have to help you solve your workplace problem. So don't be bashful. Ask those questions right now, and you can leave here feeling better with some more knowledge. Now, as I'm waiting for your questions, one of the things I wanted to talk about is, again, vaccines, because across Canada, we've had more and more governments announcing mandatory vaccinations or a form of that. So I want you to understand that unless the government has implemented mandatory vaccine for your workplace or for your industry, an employer still is not allowed to require you to vaccinate. Okay, they're not allowed to do that. Now, a lot of employers are doing it, despite what I just said. Ultimately, that's not allowed. If you lose your job as a result of your refusal to vaccinate, we need to talk. That could be a human rights violation. It could certainly be a wrongful dismissal. So we need to talk about that. Now, if the government has implemented mandatory vaccine, for example, in BC, long-term care homes, people have to be vaccinated. Well, unfortunately, there's not going to be much that you can do in that situation. But if the government has not stepped in, your employer does not have the unilateral right to impose vaccines. Okay, so remember that. I'm going to start answering questions right now. Ask your question. Take advantage. I'm here. You're here. So let's get a conversation going. So first question of the day comes from Tim on Facebook. Tim says, I was denied my company's insurance for sick leave. What can I do besides appealing it? I've already done that. So Tim, I think what you're talking probably is about short-term or long-term disability at your employer. First of all, the appeal is a waste of time. You never waste time with that appeal. It's simply a mirage of false hope. That's all it is. It doesn't do anything. The reality is, to get this resolved, you need us to give the insurance company a kick in the rear end. That's all that can happen. We have a whole department just dealing with that. That's how many of these cases come up. So don't give up, because we can get this resolved usually very, very quickly. I want you to reach out to me. I'll connect you with the head of our the disability department. He'll talk to you about what we can do to get this resolved. To connect with me, you see the email address, help@employmentlawyer.ca, or simply go to employmentlawyer.ca. But that appeal process is a waste of time, unfortunately. I think you've already found that out. So give us a call. We'll get this resolved. So thanks for that, Tim. Look forward to connecting with you. Next question comes from Wendy. If I work for a government-run long-term care home, can they fire me for not getting the COVID vaccine? So they can if you are in BC. Because in BC, the government has implemented mandatory vaccines. You cannot be fired legally if you're not in BC. For example, in Ontario, You may have to do regular COVID tests. The government has announced that, but you still cannot be fired legally for refusing to vaccinate. All right. So if the government doesn't say you have to, then the employer is not allowed to say that either at this point. So hopefully that clarifies it, Wendy. Thank you for that question. I've been getting that a lot. Next question this morning comes from David. What is the average compensation? How long do you have to wait? Do you have to go to court? So compensation for what, David? I'm not sure exactly what we're talking about here. You say average compensation, but compensation for what? Give me some more information. I'll be happy to answer that. Next question comes from Kevin. I'm a full-time employee of 8 years. Recently, there was an internal job posting for a position for a 1-year contract. I wanted to apply for the position, but what are my rights after the 1 year? Am I then terminated, or do I get severance for the previous years not covered with a 1-year contract? So if you sign a 1-year contract and at the end of that contract, they don't keep you, you're not going to be owed anything, okay, in this situation. Now, the way to deal with that is to deal with it in advance and agree with your employers to what's going to happen, that either they'll keep you in a different role or that they will pay you your full severance. But if you simply sign a 1-year contract, then and at the end of that, if you're out of a job, they don't have to pay you because you would have had sufficient notice. You would have had 12 months notice. And because you've been there for 8 years, that would be enough notice for you. So that's something you have to keep in mind, because you may lose your job without compensation. But talk to your employer. They may say, no, don't worry about it. We'll have a job waiting for you. No problem. If that's the case, great. If that's not the agreement, you may be out of a job at the end of the year without compensation. So thank you for that. Next question comes from Tim. Oh, Tim says, yeah, okay. So Tim, I've answered your question, so you know what to do. We deal with this all the time. Short-term disability, we'll take care of it. So reach out to me again, employmentlawyer.ca. And everyone else, my name is Lior Samfiru. I'm the employment lawyer. So ask your question. Oh gosh, unfortunately, the platform here, when I get a lot of questions, they get pushed down and I can't see them. So there's a question from Teresa that I can't see. And then there's a question from Polly that I also can't see. So perhaps one of the moderators here can help me see Teresa and Polly's questions, or perhaps, ladies, you can post those. Next question is from Wendy, asking for a friend who 2 years ago had surgery to have a brain tumor removed. She did eventually go back to work, but has since gone on short-term due to symptoms and side effects. Now her insurance is trying to force her back to work and may deny her long-term. What steps should she take if denied long-term? I've given her your contact info in case she's denied. Well, that's exactly what she can do. She has to contact us. We can help her get this resolved. This happens often. Insurance companies want to get people off their payroll, even if the doctor says that should not be the case. That's the bad news. The good news is it's not difficult to resolve. So have her reach out to us. She doesn't even have to wait to be denied. We can speak to her now to kind of get a sense as to what her situation is all about. Happy to speak to her. We have a whole team just dealing with that. Okay, Teresa's question was, my husband has been called back to work, but on half pay plus commission structure. Can that be done? No, Teresa, that cannot be done. In fact, that's what we call a constructive dismissal. By changing the terms of his employment, they reduce his pay, they change the pay structure. He has the right to treat that change as a termination, as a constructive dismissal. So he really has two options. Option number one is he accepts this pay reduction and continues working. Option number two, he can say, is by reducing my pay, that's a constructive dismissal. I'm choosing to leave, but you, employer, have to pay me my full severance. The problem, Teresa, is this. If he accepts this pay reduction and continues working, he gives the company the right to do it again. And the next time they reduce his pay by 50% or by any percent, he won't be able to do anything about it. He's stuck. So he's better off now to deal with this, to say constructive dismissal. If that's what he wants to do, Teresa, I want him to connect with me ASAP, now. I would not wait on this, okay? And again, to connect with me, just go to employmentlawyer.ca. Again, employmentlawyer.ca. Thank you for that. Very important question. Next question was from Polly. I received a performance improvement letter dealing with mental health issues. Disclose this to the boss. Can I ask that that be added to the performance letter that I was dealing with a health concern that caused poor performance. So it's not that you need, Polly, to ask that it be added. What's important is that you send an email to the company telling them about it. So it's on the record. You don't need them to change the performance improvement plan. But what you need to do is make sure that they know. So I would send them a letter saying, you've alleged that I've had all these performance issues. Here's what's important to understand. I've had all these mental health issues or other issues, and that's impacted my performance. It needs to be there. If you put that on the record, they're not going to be able to rely on that performance letter to let you go for cause, okay? So you don't need the change, but you have to respond in writing. Email works great. You can't just accept it. You can't be silent. Silence is the same as acceptance. So respond back, say exactly what happened, put your position and your facts on the record, okay? So that's important, Polly. I'm going to continue answering questions. Ask yours, guys. A lot of questions, amazing questions. From Sarah, federally regulated employees, if we have a business line for work from home, is my employer required to make one of these opportunities available for me? And can they enforce the vaccine on employees working in this line of business? So if I understand correctly, is if there's another position, does the employer have to consider you for it? No, unless you're part of a union, your employer does not have to consider you or anyone else and can decide to hire from the outside. So very important to remember that you don't necessarily have a right to be considered. If you're part of a union, depending on seniority, then yes, you would have that right. Now, in terms of vaccines, unless you're in an industry that the government has said you have to be vaccinated, your employer does not have the ability and the right to mandate a vaccine. Right now, any vaccine mandates have to come from the government. It can't come from an employer and can't come from private organizations. It has to come from the government. So if the federal government has announced some industries that will require mandatory vaccines, people that work for the government, people that are in transportation. If you're in one of those industries, then yes, you're going to have to at some point get vaccinated or you will lose your job. But only in these industries at this point. So thank you, Sarah. Carl asked, why doesn't your firm take on workers' comp cases? I'm not sure how to answer that. We just don't. It's simply something we don't do, Carl. Thank you. Let's see. Next question comes from Bridget. What other scenarios would constructive dismissal be an outcome? So constructive dismissal happens when an employer makes significant changes to the terms of employment. For example, a pay reduction, a change in payment compensation structure. It can also happen when there's a change in hours, reduction in hours, a change in shift. Maybe you were working morning shift, now you're working evening shifts. So anytime there's a significant change to the terms of employment. And the other form of constructive dismissal happens if you're a victim of workplace harassment. You have a right not to be harassed at work. Obviously, you have a right to a respectful work environment. So what happens if you are harassed? That's a breach of the terms of employment. So that could be a constructive dismissal as well. So hopefully, Bridget, that helps you understand. If you believe you've been constructively dismissed, call me, or if you know someone that has been, they need to reach out to me as soon as possible, because time here is extremely important. Time is of the essence. And again, to connect with me, employmentlawyer.ca. Again, employmentlawyer.ca. Those joining us, my name is Lior Samfiru. I'm the employment lawyer, and I'm live answering your questions right now. So answer or ask those questions. Next question from Gerardo on YouTube. Employer gave misleading information to unemployment office. How would it affect my benefits? Well, I guess obviously I would have to know what information they gave that was misleading. That they denied that you work there, that they give information that's wrong about your compensation, about your reason for departure. So without knowing what that information is, I can't say if it's going to impact you. So if they say that you work for 5 years instead of 3 years, as an example, or for 3 years instead of 5, it's not going to matter because you're going to get the maximum anyway. So I would need some more information, Gerardo, as to what exactly the employer said to EI that was incorrect. Okay? Ask questions, guys. We're getting some amazing, amazing questions here today. Next question from Kaswilia. Again, if I mispronounce your name, I do apologize. If an employer is unable to accommodate medical restrictions, is this considered a constructive dismissal? No. So if an employer truly cannot accommodate, if they've tried, if they looked, there's just no possibility. There's really two options. Either the employee can stay off on a medical leave, or if the employee is never going to be able to be accommodated, that could be a frustration of contract, meaning the employer can just let the employee go. So if those restrictions are not forever, the employee can stay off on a medical leave until they get better or until the employer is able to accommodate. If it's never going to be possible to accommodate, then the employee can be let go. But it's not a constructive dismissal. Now, keep in mind, the fact that the employer is saying that we can't accommodate doesn't mean that's true. I've seen hundreds of cases where the employer didn't try hard enough. Remember, an employer has a very strict and a very important obligation to provide accommodation. If you have a medical condition, they may have to provide modified duties, modified hours, etc. And if they don't try hard enough, that's illegal. That's a human rights violation. So the real question is always, can they accommodate but choose not to? Or is it legitimate that it's just impossible for them to accommodate? If you're not sure if they're properly looking at this or if they're trying hard enough, then let's talk about this, Koswilia. Happy to talk to you and get some more information. And you can connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. My gosh, a busy one today. I love this, guys. We have plenty of time left. Ask your question. Don't leave here without having your question answered. Okay? So I'm live. You're live. Let's make sure you get those answered. Glenn asks, how can the government just make vaccines mandatory? What about our charter rights regarding consent to medical treatment? Well, remember, your charter rights are subject to what we call reasonable limits, meaning that in some cases, the need for the charter violation, if it is a charter violation, is more important than the actual charter right. The reality is that what the government is doing may or may not be legal. It may not be legal, but the only way to challenge that is in court. And that's a process that's going to take years. So practically speaking, there's not going to be that much that you can do. It may not be legal. I'm not saying that it is or that it isn't. But to challenge it, it's a process that's going to have to take years to go potentially to the Supreme Court of Canada. By then, we won't even have COVID. So as a practical matter, not much that you can do. Next question today. Let's see, from Joseph. I'm 72 years old, still working. That's awesome. Congratulations. Am I still protected by all Canadian labor laws? Absolutely yes, Joseph. No question. There's no such thing as mandatory retirement. You can't be discriminated against because of your age. Not only that, if you are let go at some point because you're older, you're going to get even more severance than you would have if you were younger. Because one of the factors that go into deciding how much severance is your age. The older you are, the more severance you get. So you still have the rights and the protections of the law. Whether you're 62, 72, or 102, it doesn't matter. You can work as long as you want. You can work as long as you're able. And you are protected by our Canadian laws, which, by the way, are quite good. So thank you very much for that, Joseph. And you keep going, my friend. Okay, next question. Again, my name is Lior Samfiru, the employment lawyer. You're listening and watching the employment law segment here on social media, answering your question. So ask them so I can answer them. Next question is from Mark on YouTube. What is the difference between a permanent layoff and a termination? There is no difference whatsoever. They're exactly the same thing. A situation where you're no longer going to be working for the company can be called a permanent layoff. It could be called the layoff. It could be called the termination. It can be called being let go, being fired. It doesn't matter. There's absolutely zero difference. What matters is the compensation that you're owed, the severance that you're owed if you lost your job. And remember, Mark, in 90%, more than 90% of cases, when someone is let go, permanent layoff, termination, doesn't matter. The severance that they're paid or the severance that they're offered is a lot less than what the individual is actually owed. You could be owed as much as 24 months pay, 24 months severance. So the key here, Mark, is if you are let go, we need to talk to make sure that you got what you're owed. Once you sign off on that severance letter, you're done. There's nothing that can be done at that point. So you need to speak to me before you sign off. I don't care if there's a deadline. Every severance offer has a deadline. So you have to sign by Friday at 5 o'clock. Don't worry about that. That deadline is meaningless. Your rights don't expire Friday at 5. In fact, they don't expire for 2 years. So that deadline is irrelevant. It's meaningless. It's just a silly pressure tactic. We need to speak if you lost your job, but there's no difference between a permanent layoff or a termination. Zero. Great question. Again, my gosh, what good questions today. And to find out more, employmentlawyer.ca, again, employmentlawyer.ca, so that we can connect that way, so you can learn more about employment law. And if you go to employmentlawyer.ca, you can have my email addresses right there, my phone number is right there, so that we can have a private discussion. You know, we can have this private discussion right now on social media, but right after this is done, I turn off the camera, I get back to work, you can connect with me at the office. Next question comes from Taylor on Facebook. Are third-party contracts regulated in labor law? As an example, an employer demands that I use an online service whose terms of service include a provision that violate my personal privacy. Can I refuse and fight it as a charter of rights violation? So first of all, it's never a charter of rights violation, because the only one that can violate your charter rights is the government, right? A company, a private business, or someone else cannot violate your charter rights. If your employer wants to do something that's wants you to do something that's otherwise unsafe, that provides you, that exposes your privacy or your private information, obviously you don't have to do it, but you have to be sure that that's in fact what's happening. Okay, so you can't just refuse something, but if you know that what your employer is asking you to do is inappropriate, then they can't make you do that. You can't be punished for refusing. And in fact, just by being asked to do something that's inappropriate, that could be a constructive dismissal. But the charter has nothing to do with it. The only one that can violate charter rights is the government, okay? So the charter is a contract between you and the government, not between you and me or you and a private business. So hopefully that makes sense, Taylor. If I haven't answered the question properly, feel free to ask a follow-up, and I'll be happy to. I think I'm caught up with the questions, so ask. You got some more time, everyone, so please ask questions. But as I'm waiting for the next question, let me tell you about another tool that you have to have some information about, and that is pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. What is it? Well, the easiest way to explain it, it's like having me with you at all time. It's like having your own employment lawyer with you. Just grab your smartphone, your tablet, your desktop, whatever you want. Go to pocketemploymentlawyer.ca, and you'll have your own employment lawyer there. What can that employment lawyer do? Well, number one is it can calculate your severance. Right now, if you want to know how much severance you're owed, whether it's 6 months pay or 24 months pay or something else, just go to pocketemploymentlawyer.ca and use our severance calculator. Very great tool, probably the very first place you have to go to if you lost your job, and others tell them about it as well. But it can do much more than that. If you want to know if you've been constructively dismissed, pocketemploymentlawyer.ca. If you want to know if your employer has just cause to let you go, pocketemploymentlawyer.ca. If you want to find out if your case is considered a human rights violation, pocketemploymentlawyer.ca. That and more you can do at pocketemploymentlawyer.ca. We're using technology to essentially give you your own lawyer. It's free. It's anonymous. There's no credit cards to put in. There's no names to put in. You don't have to even put in an email address if you don't want to. But if you do want to, you can also contact me directly from pocketemploymentlawyer.ca. Okay, so take advantage of that and use it anytime you need to. Next question and again, ask your questions. We have another 7 or 8 minutes, so please ask them. Next question from Razor Sharp on YouTube. Can I request that my employer put more COVID protection measures in place? I don't feel like they're taking things seriously. So the person or the entity that decides what measures they have to take is the government. So governments have imposed measures that employers must take, whether it's social distancing, masking, limiting number of people. As long as your employer is doing that, that's all it's required to do. The fact that it could do more, but it's not doing more, is not something you can do about it as long as they're doing what the government says they must do. So if they're not doing what the government's saying it must do, you not only can you ask, you can even refuse to work. For example, if they're not mandating that people wear masks at work, even though they're required to, You don't have to work. You can refuse work and you can't be punished in that situation. But ultimately, they have to follow what the government said they must do. It's not up to you. It's not up to me. They have to follow what the government says. So hopefully that explains it razor sharp. Next question from Facebook. This is from Sarah. Do I need a formal notice from my doctor about my health condition to be able to ask my employer to exempt me from a vaccine mandate? I work in a federally regulated business. So first of all, don't assume that your employer can mandate a vaccine. Even in a federally regulated business, right now the government has said that it's mandatory if you work for the government or if you work in transportation, airlines, or railway, etc. For other industries, for example, a bank is federally regulated, but right now there's no mandate. So your employer cannot require you to be vaccinated. That said, if you have a doctor's note saying that you have a medical reason, that's better. That gives you even more of a reason not to be vaccinated. That gives you more of a reason to deal with this issue. But even without a doctor's note, an employer still, at this point, cannot force you to be vaccinated unless the government has imposed a mandate that applies to you specifically. Okay? So hopefully that answers it. Next question is from Deborah. Can an employer fire with no cause and then on statement of defense say they have cause? Yes, they can do that. But the question is, how credible is it? Is it going to be believable? Is it possible to do? Sure. But it's probably going to not help the employer's case. It's going to make their case look very weak. Because if they had cause, why didn't they say so to begin with? But it is possible. Next question from Simbat Bay. I used your pocket employment lawyer. It shows that I was offered $7,000 to $15,000 difference from the 3-week severance offered. Does it take the legal process a long time? Also, the employer doesn't want to pay out severance without me signing a release letter. So first of all, your employer is not going to pay you your severance without signing a release. That's fine. But does it take long? No. In most cases, we're able to resolve these severance issues within a few weeks, but we need to get involved. Our name on the letterhead is going to make all the difference in the world, believe me. So if you simply ask your employer, give me some more severance, they're going to say, no, thank you. If we say, hey, you have to pay more severance, they'll pay more severance. So it's not a long process in most cases. So let's speak, connect with us, and let's deal with it. Again, employmentlawyer.ca. You did the right thing, pocketemploymentlawyer.ca. Simbat Bay used the severance calculator, and she found out that she could be owed an extra $15,000 more than what she's been offered. That's not unusual. Many times people find they're owed $60,000, $75,000 more than what they've been offered. So you as well, check out pocketemploymentlawyer.ca. Thank you for that question, Simbat Bay. Next question on Facebook from Joseph. My employer uses one company to pay my main salary and benefits, etc., and instructs me to submit 2 separate invoices to separate but related under the same umbrella companies each month for work I do for these entities. Is this legal? And should I get compensated on the aggregate income if dismissed? So, Joseph, this is more than I can deal with on this type of a setting. We need to actually connect off air so I can understand the connection between the companies, the work that you do, the percentage of work that you do for the companies. Is there a difference between how you work for one company and the other? So I can't really deal with that on social media. So Joseph, we need to connect personally so that we can discuss this, and you can do that through employmentlawyer.ca, or you see right here, email address directly is help@employmentlawyer.ca. Carl says, I'm ignoring YouTube questions. No, Carl, I'm not. In fact, I answered your question. So I'm answering all the questions, and I did answer yours, Carl. So I think this is the time that we have for this week. I think I'm all caught up on those questions. So I'm going to shut off the camera and get back to work, and I will be back here next week. But please don't wait another week to connect with me. Don't sit and stress out over your questions or your workplace problems for a week. You can connect with me today if you want to through employmentlawyer.ca. You can send an email. You can pick up the phone and call, whatever you want. There's a form you can fill out if you prefer there at employmentlawyer.ca. But I will be back next week either way. It's always a pleasure to be here. I get amazing questions. Hopefully I've helped ease your mind on some of these issues. Anything to ask further, any follow-up question, employmentlawyer.ca is the place to go to. Thank you very much, everyone. Enjoy the rest of your day. Stay safe out there. And